Hello, and in this video I want to talk about the limitations of the doctrine of frustration. Now, frustration is where an external event not contemplated by the two parties occurs, and it makes fulfilling the contract radically different to then that which was imagined when they were signing the contract, or it may make it impossible to actually fulfill the obligations. Now, this doctrine cannot be applied as and when, as at the matter of a click or something, because remember, we're trying to protect the freedom of contract and the sanctity of contract and pacta sunt servanda legal maxims. So what are the limitations on it? Well, where there is an express contractual provision regarding the frustrating event that has happened, it is not necessary the contract will be frustrated. That term will be looked at and that term will be applied, saying that, if the term said that should there be a fire, then this will happen, then the courts will say maybe it's not frustrated because you had already covered that inside of your contract. The second limitation is the foreseeability. Now, where an event is foreseeable, you cannot say that it is a frustrating event. So let me give you an example. In Davies Contractors and Farnham Urban District Council, now they said the contract was frustrated because the building work took longer than imagined and was much more expensive because there was a shortage of labour and raw material costs. Now the court said that actually this is something you can foresee, you can predict, you can see that there's going to be a labour shortage if you work like this, and for that reason it is not a frustrated contract. The third thing is the frustration cannot be self-induced. It has to be an external event that's happened elsewhere. This is because if it's self-induced, then basically it's a breach. It's saying that we cannot go on, I cannot perform my obligations because I have caused the boat to sink, They'll say, well, you've breached it. It's not frustration, it's not an external event. Now, an example of this is in the Super Servant 2 1990. Now, the defendant over here contracted to transport the plaintiff's oil rig from Japan to Holland using either the Super Servant 1 or Super Servant 2. Now, these are both ships. And the transportation, so what the defendant then did is that it said that we'll use number 2 because it allocated the Super Servant number 1 ship out to a different client. However, number 2 sunk. Now this is self-induced frustration because you could have given the other ship. You have in fact caused it, and if the ship sunk for any negligent reason, that you have yourself caused it to sink, then it's even more self-induced frustration, and therefore it cannot be deemed a frustrating event. The burden of proving that frustration is self-induced is on the party that's claiming it. And the last point of this video is I just want to say that frustration should be differentiated from force majeure clauses. Also with the exception clause, the provision, the express contractual provisions we were talking about before, these are all different because a frustration renders the contract impossible. You can no longer fulfill it. Whereas the force majeure clause sees that there's a temporary difficulty and you can suspend obligations till a later date. So those are two different things. Thank you for watching.